everybody. This is the makeup for the November 11th and then the November 12th Administrative Law class. Thanks for your flexibility this week. I think I'm finally on the mend and should see you on Tuesday. I wanted to reemphasize, as I said in the email, that the exams from past years are up on Twin. And the other thing that's available there is a poll, which you can find under the customized polling link on the left-hand side of the page, and that solicits your opinion on days for a review session or sessions. I should have that figured out by Tuesday, so you should definitely try and do that sometime over the course of the weekend, because I'll try and make a final decision and come up with possibilities as far as rooms are concerned at that point in time. So what we're going to do today is talk pretty much about the entirety of Chapter 10 in the course book. And I know that I didn't have you read the first part of that chapter, but it's worth talking about a little bit just because it sort of gives a little bit of a context to the discussions that come up with respect to Section 701 and 702 of the APA in particular. I'm not quite sure at the moment how long this is going to last, but the flip only goes for an hour, as I indicated, so it's certainly not going to go that long, and I think what I'll do is divide it up at least into two parts. So what we're talking about here is the question of the reviewability of agency decisions. An agency's done something wrong. How are you going to get it into court to challenge that and to try and get some sort of a different result? Well, for any lawsuit against an agency, or for that matter, really almost any kind of civil litigation, you have to demonstrate three things. You have to demonstrate injury of some kind, you have to demonstrate a cause of action, and you have to show jurisdiction. Injury, we're not going to talk a lot about today. In particular, this is talking about both injury in fact or factual harm, which goes a lot to the question of standing, which is what we're going to talk about next week. It also means legal harm, which means that a law has been broken. Something's happened somewhere along the way that amounts to a violation of law. There's some procedural or substantive standard. The statute says the agency may only, place certain limits on the ability of industries to pollute, and the agency has gone outside the scope of those limits, for instance. Or the agency shall regulate in a manner that's necessary to protect human health of the environment, and the agency is failing to do that for some reason. Those are the legal harms associated with a particular lawsuit. And then, as we'll talk about next week, there's this question of factual standing at the same time. Once you've got injury, you also need a cause of action. And the cause of action is really the focus of our attention for today, which means somebody has to tell you you can actually bring a lawsuit associated with that legal injury. In particular, you can have situations where a statute might say you have to do something as far as a regulated injury, or an agency has to do something in order to regulate, but it doesn't give anybody the right to sue if there hasn't been or if there's been that kind of a violation. Sometimes if a substantive statute requires an agency to do something, or I guess I should say sometimes if a substantive statute requires a regulated entity to do something, it may be that the statute won't give anybody the right to a cause of action to prevent that from happening. And the only way that you might actually try and ensure that some regulated entity isn't doing something that is against the law is to try and get the government to step in and to bring some kind of an enforcement action. But if there's not a private right of action under a statute, you're not going to be able to force them to do it. Similarly, if the statute requires the agency to do something and the agency hasn't done it, then you have to find a cause of action available to you that says, yeah, you can sue the agency for failing to do that thing. That's the primary responsibility of Section 702 of the federal APA, for instance, is the provision that says you can sue the agency in certain circumstances. Now, there's other examples and other places that you can find the cause of action, but that's the heart of the cause of action. The third point, of course, is jurisdiction, and in essence, you have to demonstrate that the court in which you file the lawsuit has the constitutional and statutory authority to hear that lawsuit. We're not going to talk about this much. It's usually not a big deal. Certainly with respect to litigation against federal agencies, it's not hard because as a general matter, if you've got a cause of action, which means you've probably got yourself some kind of a statutory provision that says you can sue, you've almost automatically got yourself a federal question. So section 1331 of Title 28 U.S.C. is going to give you federal question jurisdiction in most of these federal administrative cases, and that's above and beyond the provisions that also provide for federal court jurisdiction over lawsuits against the United States, which of course you're generally going to have as well. So as a general matter, the jurisdictional element is not very hard in federal court. The only hitch that you might get into is a few exceptions where the courts try and say, well, we don't really have jurisdiction over this problem because we're going to defer to a separate branch. This is something that fits into the category of sort of separation of powers kind of thing. But other than that, the federal courts, generally you're going to have federal question jurisdiction. State courts, usually courts of general jurisdiction, so it's usually not too hard to get general jurisdiction there. So injury, cause of action, jurisdiction, those are the main things that you need for any lawsuit. And what we're going to focus on today is the causes of action against agency decisions. So a couple of preliminary points on this. First of all, you always need to think when you're suing a governmental entity about the problem of sovereign immunity. The idea of sovereign immunity, of course, is that you just can't sue the sovereign. And in particular, in these cases, you can't sue the government. And of course, if you can't sue the government, that's going to cause some real problems when it comes to the question of seeking judicial review of agency action. This is based, of course, on the old idea, well, the king can do no wrong, or the queen can do no wrong, and that's the traditional notion of sovereign immunity. The newer idea, in a lot of ways, justifies sovereign immunity as a notion that risks that are posed by litigation against the government, and in particular are risks that are posed to everyone, right, to the entire public. And as a general matter, with a few exceptions, of course, we are often willing to say, well, we're going to allow injury to be suffered by one person that might otherwise be borne by a large number. Now, that sounds harsh, and as a practical matter, of course, there are a lot of exceptions to the general rule of sovereign immunity. And so the place to begin, though, is with this idea that sovereign immunity exists. If you want to sue a governmental entity or actor of any kind, you want to try and ensure that you have a cause of action that waives sovereign immunity. As long as we start there, then you are going to be adequately attentive to the concern that you're not just kind of making up some sort of a cause of action. Well, I'm just going to go off and sue the government on any old theory. You have to find the mechanism to do it, which generally means you need to find some sort of a statutory basis for the cause of action. As I've said, there's a lot of ways around it, and basically everything that we talk about in the next 15 minutes or so are different ways around the general rules of sovereign immunity, either at the federal court level or at the state court level. The second sort of general point that I want to make before we talk about major causes of action is the general presumption that you have a means of getting judicial review if you have some sort of a legal injury. Now, while not all harms necessarily have remedies, in a lot of ways the very fact in the federal system of the federal APA creates a presumption that there is a mechanism out there that provides for a way of suing federal agencies when somebody has been injured, if there's somebody that's been adversely affected or aggrieved. And in fact,